Hi, my name's Jim Alder. I'm a Salt Lake City estate planning attorney, and I'd like to talk to you a little bit today about using a gun trust to purchase Class 3 weapons, such as suppressors, short-barreled shotguns or rifles, or fully automatic weapons. There's two ways to purchase those Class 3 weapons, otherwise known as NFA firearms or Title II weapons. You can buy them individually, or you can buy them through an entity. An entity can be used to acquire a Class 3 weapon, and that can be an LLC, a corporation, a partnership, or even a trust. Now, why would you want to use an entity to acquire a Class 3 weapon? There are a couple of benefits to doing so, and the first answer is because it avoids some of the requirements of the ATF Form 4 application for a transfer of a Class 3 weapon. When submitting a transfer application to the ATF, an individual must supply photographs, fingerprint cards, the signature of the Chief Law Enforcement Officer, or CLEO as it's called in the jurisdiction. However, when an entity submits that same application, these three requirements don't apply. Therefore, the application process is significantly simplified, and you as the individual retain a greater level of privacy. Most important, in many areas, the CLEO signature is extremely hard to obtain, if not impossible. Many legal offices are now refusing to sign the Form 4 application for fear of being held liable if an automatic weapon owner commits a violent crime with a Class 3 weapon. In such cases, an NFA trust can be invaluable in acquiring a Class 3 item. So, other benefits of a gun trust. Probably the most important benefit of holding NFA firearms in an ATF-approved gun trust may be the opportunity to allow others to use the weapon without fear of committing a felony. The National Firearms Act prohibits a transfer of the restricted weapon without ATF approval of the Form 4 transfer application and payment of the associated tax of $200. In addition to selling and conveying, the definition of a transfer includes the word loaning of the weapon. Now, many enthusiasts have suggested that allowing a friend to use the weapon in your presence is not a transfer, but it would appear that the statute would suggest otherwise. Even if the ATF may not prosecute the loan of an automatic weapon, where loan is defined as allowing a friend to fire the weapon in your presence, it would not appear wise to rely on this understanding. It seems highly likely that the ATF would be forced to prosecute such a loan as a prohibited transfer if someone were injured or killed by the use of the weapon by the friend. Now, this scenario is completely avoided by use of a well-drafted gun trust. Family and friends can be added to the trust as lifetime beneficiaries who are entitled to use the assets of the trust. These beneficiaries can be added and removed by use of a separate schedule of beneficiaries that is incorporated by reference into the trust. So assume you're going on a camping trip with a number of friends and anticipate doing some shooting. You add the friends to the schedule of lifetime beneficiaries, take a copy of the trust and the schedule with you, and if you're ever approached by law enforcement about the use of an NFA firearm, produce the trust to demonstrate that everyone using it has the legal right to do so. A properly drafted gun trust also allows you to differentiate between lifetime beneficiaries who may use the weapons and those beneficiaries who should inherit the assets of the trust after your death. It can also be structured to hold the weapons in perpetuity, assuming that this is allowed under the laws of your state of residence. In making distributions of trust assets, a properly drafted gun trust will give the trustee very explicit instructions as to how to properly administer the distribution of those weapons to your beneficiaries in order to avoid a prohibited transfer at your death. Now, a word of caution. It's very important to recognize that a gun trust is significantly different than a revocable living trust used for general estate planning purposes. A gun trust is a special purpose trust designed to accomplish specific objectives and reflects the firearms laws controlling the use and transfer of these items. A revocable living trust, on the other hand, allows or even instructs the trustee to do things that may be a direct violation of federal firearms laws. Therefore, estate planning software or online trust services such as LegalZoom or Quicken Will Writer should never be used as a substitute for a gun trust prepared by a competent gun trust attorney in an effort to save a few dollars. There is far too much at risk, both for you and your family and friends. If you'd like more information on gun trust, please visit our website at www.alder-robb.com. That's ALDER-ROBB.com, where you can navigate to the gun trust section and read some more about it. Please contact us at the numbers information that you find there if you have further questions. Thanks again.